Hi, I'm Vivian Dempsey. I teach the Writing Edge Bar Review course. I specialize in repeat takers on the California bar and attorney bar applicants because I teach the two written parts of the bar exam, the essays and the performance tests. Today I'm going to give you a 2-minute summary, I hope, of the winter 2014 bar exam. This is my homage to Ezra Klein, who used to be with WonkBlog and just started Vox.com, which is really cool. And he does these complex issues and tries to summarize them in 2 minutes. So this is the quick overview of the winter 2014 bar exam. Question 1 was a total PR question, and the entire theme of the question was prosecutorial misconduct. It included pretrial publicity, ex parte communication with the judge, no probable cause to prosecute, failure to disclose to the defense exculpatory evidence, and misrepresentation of fact in court. The fact was that the prosecutor was ready for trial at a time when she just learned that the only evidence they were relying on was unreliable. Question 2 was community property. It also had a theme, and the theme in it was changes to title to property. So 4 of the issues involved changes to title. Gift of community property that was personal property, but it was part of the hearth and home. And that can be voided at any time. Transmutation of real property, which of course requires a writing. It can't be done verbally. Taking title to property in one spouse's name when the source of it is community property, and the title presumption is the starting place, and then it is self-serving, and the court will ignore the title and look to the source. Conveying real property that is community property titled to a bona fide purchaser for value who does not have notice that it's community property, and that can be voided by the non-donative spouse, a non-conveying spouse, up to a year. But because of the need to settle title to property, it's only within a year that it can be voided, and the spouse who's objecting to the sale of the property must reimburse the BFP, who didn't have any knowledge, must reimburse the purchase price to the BFP in order to undo the sale. And the only issue that was not about changes to title was reverse Pereira Van Camp. The business that the wife worked in was funded by community property. And after they permanently separate, she continued to appreciate the value of the business. But of course, after permanent separation, there is no more community property. And so reverse Pereira Van Camp applies in that situation, and the community property, the funding source, gets a reasonable return on the value, on the investment, and all the rest goes to the spouse working in the property. The third question was civil procedure, a bit of an unusual one. The main issue, probably I'd say 75% of the points in the question, went to the first issue, which was a bread and butter issue. That was federal subject matter jurisdiction. Understand that if a question has 3 interrogatories, they're not necessarily of the same weight. And very frequently the bar freaks you out by having something that's a tiny, tiny little issue and you think you've blown it entirely when it really wasn't worth a lot of points. And if you can just remain calm when all others around you are losing their cool, you can still do quite well on that question. So the first issue was subject matter jurisdiction, and it had removal and remand, which are sub-issues of federal subject matter jurisdiction. The removal was improper because the amount in controversy was only $20,000, and also because the defendant was a citizen of the state that where the state's court case had been filed. So on both of those bases, it was improper. Then the plaintiff moved for remand. It was denied. Okay, so the second issue was whether or not the plaintiff can appeal the denial of remand immediately. And that's, of course, the good old-fashioned final judgment rule. People only get one right to appeal. They have to wait until there's a final judgment. They roll up all their issues at that time and get one right to try them in the appellate court. And so an interlocutory appeal is not permitted. The third issue, though, was on an exception to interlocutory appeals not being permitted. In the case where there's extreme prejudice to the party seeking the interlocutory appeal, and he gets dual certification, both from the district court and from the appellate court, allowing him to appeal automatically. Now, you might not have known that rule. So there was an alternative issue that would have handled question 3 entirely. And that was, he filed the appeal 6 weeks after the court's judgment, the court's order. And therefore, he wasn't entitled to an appeal just based on the fact that he did it too late. He would have had to show excusable neglect for failing to file the appeal. And of course, the order was to rehire, to reinstate the plaintiff on his job. So he would have had to have known what the court order was. So there wasn't any basis for excusable neglect. The fourth question was real property, and there were 2 theories by which the plaintiff could sue the neighbor who was excavating for an office building. Now, an office building would have a fairly deep footprint. It would have to go fairly deep into the ground, so the excavation was going to be substantial. The 2 issues are there's strict liability for failure to provide subjacent and lateral support to neighboring property. However, that only applies as strict liability when the land is in its natural state. It doesn't have a building on it. Here, there was a building on it. The building crumbled and fell. And so the strict liability theory wouldn't apply. Then only with negligence would the plaintiff be able to prevail. And the negligence here was a fairly easy case to make. The only issue that I saw that was kind of interesting in it was sort of an eggshell skull plaintiff issue, which is you have to take the plaintiff's injuries as you find them, even if it was an unforeseeable injury. And here, the whole building fell down because of the excavation. But number 1, there was a buckling wall. That should have been obvious to the defendant. And second, the owner of the building that fell down said, hey, you're hurting my property, please stop the excavation. So the negligence case is easily made. The other 2 issues were, again, a little bit more unusual. One was zoning, and it involved grandfathering in a property that existed before the zoning code went into effect. Grandfathering is okay when the property remains as is. But as soon as that property needs to be rebuilt, okay, needs a building permit, probably for any reason, the grandfathering won't protect it, and the building permit will be denied because it's not compliant with zoning. That was the second issue. And then the third issue was Recording Act statutes. There are 3 Recording Act statutes, and 2 of them require that the prevailing party have had no notice of the prior lien. And the party in this case did have notice that there was a prior lien. And so both of those bases would fail. The only one that would have succeeded is a pure race statute that would have succeeded for the bank. Okay, and then the last issue was priority of liens. The first lien on the property, the first mortgage, is going to be paid off first and will be paid off fully before any of the money on foreclosure is available to the second mortgage holder. And that was another issue in the question because the first lien holder said he wanted a proportional share of the foreclosure, and that's incorrect. He would have gotten paid off completely. Those were, I think, the fairly straightforward questions on this bar exam. The ones I want to concentrate on in separate segments here are question 5, which was the con law question, and it concerned the 3 First Amendment issues of speech, exercise, and establishment clause, and question 6, the remedies question, which I thought was definitely the hardest one on the bar. And I want to go into those in much more detail. And then I want to do the 2 PTs. PTA was very, very difficult, and that was a mothership. And if you don't know what a mothership is, stay tuned. And I'll be talking about that on a separate video. And then PTB, which is a very straightforward performance test that had 3 cases, 3 issues. So that's it for the big wrap up, and kudos to you, Ezra Klein, for your 2-minute summaries of complex issues.